Criminal Procedure. Chapter 10. Detention of Accused. Article 101. If the suspicion of the accused committed a crime becomes significant after the interrogation by a judge, and one of the following conditions applies, and as a result it will be very difficult to prosecute or try the case or execute a sentence without a retention order, the accused should be detained. 1. The accused has absconded, or if there are sufficient facts to support the concern of his absconding. 2. There are sufficient facts to support the concern that the evidence may be destroyed, fabricated, altered, or that accomplices or witnesses may be colluded. 3. The penalty for the crime committed is death, life imprisonment, or a minimum of 5-year imprisonment, and there is sufficient reason to support the concern for absconding, destroying, fabricating, or altering evidence or colluding with accomplices or witnesses. When the judge is conducting the interrogation as described in the preceding paragraph, the prosecutor must be present to state the reason for requesting detention and to provide necessary evidence. However, in the case of the proviso as described in Article 93, Paragraph 2, the prosecutor shall be present to state the reason and specify the scope of restriction or prohibition. The facts, the specific content of each reason, and the relevant evidence on which the provisions of every subparagraph of the first paragraph of 101 are based shall be provided to the accused and the defense attorney and shall be specified in the transcript. However, pursuant to the proviso as described in Article 93, Paragraph 2, the case file and the evidence that the court has prohibited the accused and the defense attorney from knowing shall not be used as the basis for detention review. The accused may petition the judge to provide appropriate time for preparing the defense before proceeding with the interrogation as described in the first paragraph of 101. Article 101-1. Where an accused, after being examined by a judge, is strongly suspected of having committed one of the following offenses, and where there exist facts that are sufficient to justify a view that the accused may repeatedly commit the same offense so that it is necessary to detain him, the said accused may be detained. 1. The offenses of arson, as provided in paragraph 103 of Article 173, paragraph 124, paragraph 1, 2, 04 of 174, or paragraph 102 of Article 175, and the offense of constructive arson as provided in Article 176, and the offense of hijacking an aircraft as provided in Article 185-1 of the Criminal Code. 2. The offense of forced sexual intercourse as provided in Article 221. The offense of aggravated forced sexual intercourse as provided in Article 222. The offense of forced obscene act as provided in Article 224. The offense of aggravated forced obscene act as provided in Article 224-1. The offense of sexual intercourse or obscene act against an insane person as provided in Article 225. The combined offense of forced sexual intercourse or forced obscene act as provided in Article 226-1. The offense of sexual intercourse or obscene act against an underage child as provided in Article 227. The offense of homicide as provided in paragraph 1 or 2 of Article 271. The offense of homicide against the lineal blood ascendant as provided in Article 272, the offense of inflicting bodily injury as provided in paragraph 1 of Article 277, or the offense of inflicting serious bodily injury as provided in paragraph 1 of Article 278 of the Criminal Code, or the offense provided paragraph 1 of Article 25 of the Sexual Harassment Prevention Act, unless where the offense concerned is only chargeable upon complaint, and such a complaint is not filed or has been withdrawn, or where the period of time for filing such a complaint has lapsed. 3. The offense of human trafficking as provided in Article 296-1. The offense of transporting a forcibly abducted person as provided in Article 299, or the offense of forced imprisonment as provided in Article 302 of Criminal Code. 4. The offense of forcing as provided in Article 304. The offense of threatening personal security as provided in Article 305 of Criminal Code. 5. The offense of larceny as provided in Article 320 or 321 of Criminal Code. 6. The offense of abrupt taking as provided in Articles 325 and 326. The offense of robbery as provided in paragraph 1, 2, and 4 of Article 328. The offense of aggravated robbery as provided in Article 330. The combined offense of robbery as provided in Article 332. The offense of piracy. The offense of piracy as provided in Article 333. The combined offense of piracy as provided in Article 334 of Criminal Code. 7. The offense of fraudulence as provided in Article 339 or 339-3, or the offense of aggravated fraudulence as provided in Article 339-4 of the Criminal Code. 8. The offense of extortion as provided in Article 346. The offense of kidnapping as provided in paragraph 1, or 3 of Article 347. The combined offense of kidnapping as provided in Article 348, or the offense of constructive kidnapping as provided in Article 348-1 of the Criminal Code. 9. The offense is provided in Article 7 or 8 of the Controlling Guns, Ammunition, and Knife Act. 10. The offenses provided in paragraph 1 to 4 of Article 4 of Narcotics Hazard Prevention Act. The offenses provided in Article 34 of Human Trafficking Prevention Act. Provision of paragraph 2 to 4 of the preceding article shall apply mutatis mutandis to the circumstances in the preceding paragraph of this article. Article 101-2. After examining the accused, despite the existence of circumstances specified in Section 1 of Article 101 and Section 1 of 101-1, the judge may nevertheless order that the accused be released on bail or to the custody of another, or with a limitation on his residence if the detention is deemed unnecessary. If the circumstances specified in Article 114 exist, the detention shall not be permitted unless the accused is released on bail or to the custody of another, or with a limitation on his residence is not workable. Article 102. A writ of detention is necessary to detain an accused. A writ of detention shall be fingerprinted by the accused and specify the following matter: full name, sex, age, place of birth, domicile or residence of the accused, offense or article of court charge, reason for detention and the fate based upon, the place of detention, time period of detention and its starting date, remedy available for challenging the order of detention. The provisions of Section 3 of Article 71 shall apply mutatis mutandis to a writ of detention. A writ of detention shall be signed by a judge. Article 103. The execution of detention shall be during the stage of investigation administered by a public prosecutor, and during the stage of trial administered by the presiding or commissioned judge. A writ of detention shall be executed by judicial policemen by sending the accused to the specified detention house. The officer in charge of the house shall, after confirming the identity of the accused, note the date and time of the admission on the writ of detention and sign his name. In the execution of a writ of detention, the writ shall be sent to public prosecutor, the detention house, the defense attorney, the accused, and the relative or friend appointed by the accused. The provision of Article 81, 89, and 90 shall apply mutatis mutandis to the execution of detention. Article 103. 1 in the proceeding of an investigation if the public prosecutor, the accused, or his defense attorney deems it is necessary for protection of a detention house and for the preservation of the safety of the accused detained, and for other proper reasons, he may apply to the court to change the place of detention. A notice of change shall be sent to the public prosecutor, the detention house, and the defense attorney, the accused, and the relative and friend appointed by the accused if the court make a change in the place of detention based on application according to the provision of the preceding section. Article 105. A detained accused may be placed under restraint only if such restraint is necessary to accomplish the purpose of a detention house or maintaining order in a detention house. An accused may have his own food and daily necessities, may receive the visitors, may send and receive mail, and receive books and all other things, but the detention house may censor them. If a court deems that the meeting with the visitors and the sending and receiving of mails or things as specified in the previous section produce facts sufficient to justify an apprehension that the accused may escape or destroy, forge or alter evidence or conspire with the co-offender or witnesses, the court may, upon application of a public prosecutor or motu proprio, prohibit the meeting, sending, and receiving, or seize the thing received. In case of an emergency, the public prosecutor or detention house may take necessary action, provided that the same shall be referred immediately to court concerned for approval. The object, scope, time period subject to prohibition or seizure made in accordance with the provision of the preceding section shall be decided in the stage of investigation by the public prosecutor and in the stage of trial by the presiding judge or commission judge. The same shall be enforced by detention house under the instruction of above referenced person, provided that nothing can be done to restrain the accused justified right of defending himself. No restraint shall be placed upon the body of the accused unless sufficient facts exist to support an apprehension of violence, escape, or suicide. Such restraint shall be taken by the officer in charge of the detention house only in the case of urgent necessity, and such action shall be referred immediately to the court for approval. Okay.